the next section of our rules, specifically the safekeeping of funds and other property. So this section of the rules makes up 2 to 8% of your total exam. The first rule that I want to point out is the safekeeping of funds. More specifically, when a client prepays a lawyer for services or otherwise gives the lawyer property, the lawyer is supposed to keep it separate from its own and not steal it or borrow it or use it for their own personal advantage. So that is the general rule. If your client gives you money, maybe as a retainer to prepay for your services, you can't use it like your own. It's supposed to be separate from your own money or your firm's operating account. You can't borrow it and then pay it back. The general rule is that it is not yours. I want to give you a quick tip. Be on the lookout for a no harm, no foul like answer choice. Oftentimes they'll tell you that a lawyer borrows money from a client. They never find out about it because they're paid back before they could ever find out about it, and that ultimately the client isn't harmed. But that doesn't matter. Remember, if there's a rule violation, there's a rule violation. It doesn't matter that the client wasn't harmed as a result. So a few things to keep in mind about this rule. Be on the lookout for fact patterns that discuss large sums of money being given to a lawyer by a client or small sums of money, because the rules are slightly different. So when it comes to a large amount of funds that the client is giving a lawyer, the lawyer is supposed to put that money in a separate account with their client's name on it so that the client can keep all of the interest that it bears. Why? Because if it's a large amount of money, they should get any interest earned on it. It is their money after all. When it comes to a small amount of funds that a client gives a lawyer, they should put it into a pooled client trust account. All states have what we call interest on lawyers' trust accounts, or IOLTAs for short. So again, if your client gives you a small amount of money, you can put all of that in a pooled account. And the idea behind this is that the interest earned on these IOLTA accounts does not belong to the clients, but instead it's sent over to your state bar to use. Usually it's given to some sort of legal foundation for use. Now, this action has been challenged and our Supreme Court heard it, and they decided that this was not a taking. In other words, this is permissible for lawyers to put small sums that their clients give them in these pooled trust accounts, and the clients are not entitled to keep the interest on them. So keep that in mind. Now, in terms of a location, lawyers are supposed to keep their client trust accounts in the state in which they practice law, unless they have consent from their client or a third person to keep their accounts elsewhere. Now, when it comes to other types of property, usually for MPRE purposes, we're talking about money, and I feel like in real life, most lawyers are dealing with money when it comes to client property. But in the event a client entrusts their lawyer with a piece of property, please be aware of this rule. The rule states that property shall be identified and appropriately safeguarded by the lawyer, and complete records of such funds and other property shall be kept by the lawyer and preserved for a period of 5 years after the termination of that representation. So for example, if your client gives you a diamond ring to hold on to, that's fine if you want to hold on to it, but then you need to identify it as the client's and safeguard it. In other words, don't put it in your own personal jewelry box. Instead, this is likely the type of thing that would be kept in, say, a safety deposit box, and probably in some sort of container that further identifies it as your client's property. So when it comes to client trust fund accounts, the rules tell us that any money that a lawyer receives but has not earned, so like a retainer or like an upfront deposit that's very common for clients to give lawyers, the lawyer has to immediately take that money and put it into a client trust fund account that is separate from its own personal account and that's separate from the law firm's operating account. So remember, we're keeping this completely separate so that there's no commingling of assets. And further, lawyers are not supposed to put any personal money or law firm money into this client trust fund account because that would amount to commingling of assets, which is a violation here, unless the money being placed in this client trust account is for the sole purpose of paying bank charges. But the rules make it clear that you're only ever allowed to deposit as much money as is necessary to cover those types of bank charges. So I want to give you a quick example. If your client gives you $15,000, let's say, as an upfront retainer, and you deposit it into your IOLTA, your client trust fund account. So you're doing everything right so far. And the case starts to progress, and you realize very quickly that there's not enough money in that account to cover bank fees and your expert witness fees. So you decide to put some of your own money in that account to make sure that everything is covered. Have you done anything wrong? And the answer is yes. While you're technically allowed to put in the exact amount of money necessary to cover the banking charges, you are not allowed to cover things like expert witness fees. So this distinction is very small, but it's a distinction that you should in fact have on your radar. So now that we know what we're supposed to do with the client money, we immediately put it in this client trust fund account. When can we withdraw it? Well, the rules tell us that you can withdraw funds only as you've earned your fees or only as expenses are incurred, which makes sense because it's not your money. You're just holding it in trust until you have to pay out expenses on your client's behalf or pay yourself for fees that have been incurred. Now, what if there's a disputed claim, which is always the question on the MPRE? If there is a dispute, the lawyer is supposed to keep the amount that's in dispute in the client trust fund account until the dispute is resolved. The lawyer shall promptly distribute all portions of the property to which there is no dispute over. So let's break this down. Let's say your client gives you $10,000 upfront as a retainer, and you work on the matter and you successfully resolve it, and you bill your client $8,000. The client says, I don't think I owe you $8,000, I think I only owe you $7,000. What should you do? Well, the rules are really clear. It says first we hold whatever is in dispute in the client trust fund account. Then we disperse all the rest. So at a minimum, your client agrees that you're owed $7,000. So you're going to pay yourself $7,000. You're disputing over that $1,000, so you're going to hold that in trust. And then finally, you're going to give back to your client what you both agree at a minimum is your client's, which is $2,000. The other thing I want to point out about this rule is be on the lookout for fact patterns that explain that your client owes other people money and what you're supposed to do with those claims. Follow the general rule we just discussed. Hold the amount that's in dispute in trust until that dispute is resolved. So let's say your client won $800,000 in a personal injury settlement. And let's say that a credit card company of your clients found out about this lawsuit and they contacted you and said, hey, your client owes us $10,000. And let's say their cell phone provider also reached out to you and says, hey, your client owes us $2,000. What you should do is circle back to your client, let them know about these claims. And hopefully your client just gives you the green light to pay them on their behalf. Now, if your client says don't pay the cell phone company, for instance, you should hold the amount in question in trust until that dispute between the cell phone company, for instance, and your client is resolved. So that wraps up this section on the safekeeping of funds and other property.